But thank you so much to everyone who's joined today. We're really looking forward to sharing some of these findings with you. So I thought I'd just introduce the team initially. So we've got myself, so I led the test and trial, and I'm Charlotte Chivers. I'm a research fellow at the Countryside and Community Research Institute at the University of Gloucestershire. And with me I have the rest of the team. So Lucy Barclay has been the project officer and research assistant on this project. So she has done most of the legwork. She's been amazing. She's done so much research on this project, and it's been brilliant to have her on board. We then have Chris Short, also from the CCRI, and Chris has been heavily involved in helping to sort of co-lead the project and make sure that I don't go off piste. And then we've got Hannah Bloxham. So Hannah is from Stratton Parker, and she's been an absolute godsend in terms of looking at the legalities of long-term agreements, and she has helped us with drafting a head of terms long-term agreement. So today, as I've said, we're going to be sort of presenting the final results of our ELM test and trial. So this test and trial has been looking at landscape recovery and the potential of long-term agreements. So that's quite an exciting potentially topic, because you know, if you're able to then think in the long term, you may be able to achieve a lot more in terms of delivering environmental benefits. So just because a lot more people have joined since I sort of set the ground rules, just to say, please keep your cameras off and stay on mute for now. We'd love to see all of your faces, but with bandwidth and things, it's probably more straightforward if just the speakers have their cameras on for now. Please do use the chat to post questions. We've put in a nice long Q&A for you, because we want to make sure that we continue co-designing even now. So even though these are the final findings, we are still very receptive to anything that participants and attendees today might have. So what I'm going to do first of all is I'm going to actually launch a quick poll, because it'd be really interesting to know how much knowledge you all sort of have around long-term agreements before we get started, and we'll then monitor this again at the end. So I'm going to launch a poll just briefly now, so if you could please just take part quickly. We will then I will then actually explain what long-term agreements are before we go into the test and trial itself. Okay, so it's really interesting. There's a really good mix here. I can see we've got quite a few people saying they haven't got any knowledge, or we've got a little bit, lots of basic understanding, and some a good amount. That makes sense, because looking at participant lists, we have got a real mix of different people. So that's brilliant. So I'll just let that run for another second or two. Yeah, brilliant. Still going up. And we haven't got anyone saying that they're experts. I'm sure some of you are experts. This is the thing. I don't think anyone likes to say they're an expert, but actually, you know, looking at the participant list, we've got lots of experts here, which is absolutely fantastic. And we're looking forward to getting your feedback. Okie doke. Okay, so 97% of you have participated. That's brilliant. Thank you so much. So we'll end that poll now. So yeah, so that's really interesting. We've got a good mix. So I'll now go into the presentation itself. So I thought I'd just give a quick introduction to the CCRI itself. So because we've led this test and trial. So for those of you that don't know much about the CCRI, we are actually the largest specialist rural research centre in the UK. And we work at the interface of agriculture, society and the environment on lots of different issues relevant to rural and urban development. So as an example, I tend to work on topics relating to soil and water and agri-environment schemes. And whereas we have other people working in urban settings and urban food production and things. So we span quite a lot of different areas across us, and we've got about 35 researchers and PhD students as well. And we sit within the University of Gloucestershire. So and in terms of a discipline, we're largely interdisciplinary social scientists. So we like to work with various stakeholders and people on the ground to conduct social science that hopefully is sort of policy relevant and hopefully useful too. That's always the goal. And the research that we carry out, it does spread across the UK and wider. So we are involved in several EU level projects as well. So you can see a few examples of our projects. Feel free to look them up afterwards if you would like. So I'm going to go straight into talking briefly about landscape recovery. So for anyone who isn't aware of what landscape recovery entails. So this is the top tier of the incoming environmental land management scheme that Defra are introducing. So this is coming in a sort of on the onset of Brexit, so it will be providing farmers with payment for delivering various sort of environmental goods whilst producing food in most cases, but with landscape recovery, because it's the most ambitious tier environmentally, it will often be sort of large scale, long-term approaches for producing these environmental and climate goods. So it might involve quite radical and large scale changes. So for example, rewiggling rivers or land use change. And in some cases, it might be a move away from agriculture, depending on the land. These agreements are also likely to be quite bespoke. There's a minimum of it's 50 hectares actually, and then was it? Yeah. Anyway, and you have to have so the issue is with landscape recovery is because there's a minimum hectarage with the agreement. There's a risk of smaller land managers and also tenants being excluded. So this was a key concern for us when we led the test and trial. So we tried to find ways to sort of help them to collaborate. So there are also now 22 landscape recovery projects that are in development stage, and they are due to start in 2024. So in terms of what we mean by long-term agreements, so by this we mean that they would be 30 years upwards, with the ambition of actually becoming perpetual. So this would prevent any reversion hopefully afterwards, and you would genuinely hopefully achieve landscape recovery at scale. So the most common sort of long-term agreements that you get globally are usually conservation covenants. And conservation covenants are often seen in the US, Australia and New Zealand. You can read a lot more about these in our rapid evidence assessment report. We can send a link to this in the chat afterwards, because Lucy did lots of research into these sort of existing long-term agreements that do happen worldwide. Obviously, you have to consider the context here. So contextually, they're very different, spaces and geographically speaking, as well as societally speaking. So it's sort of, we've been looking into whether this style of agreement could work in a UK setting. So typically these agreements are made between a landowner and a conservation body, and this is to ensure the conservation of natural or heritage features on the land. And they're also sort of private and voluntary arrangements made in the public interest. So they could be either, you sometimes get a blend, and they're usually tied to land title. So this has interesting implications too. So if land is sold and it's under a conservation style agreement, this can lead to various challenges because of the fact that these continue to be effective even after land changes hands. So in terms of our key policy questions, so Defra, when they sort of put out tenders for for ELM tests and trials, they have sort of key policy questions that they need answering. And these are the sort of main questions that we decided to tackle. So we've been looking at sort of how should long-term agreements linked to nature recovery be structured in lowland productive agricultural systems. So whilst there's been other tests and trials looking at long-term agreements in different settings, such as on common land, we have focused on lowland productive agricultural systems, which comes with a whole range of issues of its own. And also how to construct long-term agreements to safeguard investments in land use change and associated environmental outcomes. And how to structure them for different land ownership structures, because we wanted to make sure that we were considering, tenants and smaller landowners as well as the larger land managers. In conjunction with that, we've been looking at ways of blending finance, because the likelihood is, from what we've heard, that landscape recovery long-term agreements may well include a blend of different financing. So it would be public money as well as contributions from private sources of funding. So we've been looking at ways of incentivising that participation by working with potential funders and stakeholders who might be involved in these agreements. The appropriate payment mechanisms, that might be stacking payments, it might be blending payments. There's lots of different approaches, but we'll go into that shortly. And also how to structure these payments over the long-term agreement to achieve high quality and quantity of outcomes, whilst balancing stability of revenue and investor return. So things like inflation come into it, and also, you know, what payment rates are fair across the 30 years. So in terms of our study area, so we focused, as I said, in a lowland productive area. We worked closely with Southern Water when we were developing the test and trial, so we decided to stay in that area because we had a really good farmer cluster that we were able to work with, sort of in the Arran to Ada area. So we've worked with participants mostly across that area. However, a lot of our stakeholders have been more national due to the nature of them. So I'm now going to hand over to Lucy, who's going to talk about the nitty-gritty of what we've been up to, the methods we've used, and also the results. So yeah, I'm really, really pleased to introduce Lucy. She's done an incredible job for this test and trial. So here we go.
Thanks, Charlotte. Hi, everyone. So to start with, if I give a quick overview of the participants who joined us throughout the test and trial. So overall, we had 35 participants, 13 of whom were agricultural land managers, and we had 22 who were non-farming stakeholders. And those agricultural land managers, there was a mix of landowners and tenants. Many were both. Most were arable farmers, and most had previous or current experience with agri-environment schemes, particularly with countryside stewardship. 7 of those also had experience with accreditation schemes such as Red Tractor, and 7 of them were part of a farmer cluster, with 3 clusters being represented in total. And we also had a facilitator from a further cluster join us as well. And there was a real range of opinions towards land management, farming and the environment amongst those participants, and a range of opinions as well as to how things might change in the future and how things perhaps should change in the future. But it's quite important to stress at this point that all of the farmers from the core group who participated throughout the test and trial demonstrated really strong environmental stewardship values, but that the priority or maybe the weighting given to that relative to agricultural production on their land differed quite greatly. So we were able to gain a really good range of opinions and to help inform our policy recommendations and the development of the template long-term agreement. Next slide, please. So among the non-farming stakeholders, again, we had a really nice range of backgrounds and priorities and opinions. So Southern Water was a key stakeholder in the test and trial, as Charlotte's already mentioned, and was particularly helpful in shaping our understanding of potential investment into long-term agreements. We also had stakeholders from the National Trust, from wildlife trusts and local nature partnerships, who gave us a really good range of views on land management and the environment that we could compare and contrast with each other and with those of the agricultural land managers. And we also had some key stakeholders that really helped our understanding of matters such as conservation covenants and natural capital markets. So this diagram here, you can see the test and trial kind of as a whole. So across that centre strip, we began with desk research, with a rapid evidence assessment, and then those grey arrows show each stage at which we had farmer and stakeholder input. So at every stage, we tried to encompass as many of the views as possible into our thinking for the next stage, so that we were making sure that we truly kind of co-designed the outcomes throughout. And right at the end, we had a kind of final set of evaluation interviews to really double check or maybe triple check our outcomes, our conclusions, our policy recommendations, as well as the template agreement before those have been sent to Defra. So there was a constant process of learning from the participants and feeding those learnings back into our own thinking. Next slide, please. And very quickly, I'm going to run through our key findings from each stage of the test and trial, so that when we discuss our policy recommendations in more detail towards the end of the webinar, you've got the context for those conclusions that we've drawn. I think I've just seen it pop up that Charlotte's put a link, or is going to put a link to our final outputs in the chat. If you want more detail on any of these there. The final report gives a really in-depth overview of the whole of the test and trial. So I'll try and keep this brief because of time. So as Charlotte said, we found that the conservation covenant really predominates in the literature on existing long-term agreements. But as she already mentioned, the context, the different legislative contexts are really important to bear in mind. So for example, in the US, they're widely used to restrict development on agricultural land within a planning system that's very different to the UK's. So it's not necessarily particularly straightforward to transfer learnings from these different contexts to our own in the UK. We found there's a lot of literature on agri-environment schemes, and we were able to usefully take some learnings from this, especially surrounding how to support cooperation or collaboration amongst land managers. We found that building trust, social capital and group learning and knowledge exchange are really important in these factors. We found that, perhaps unsurprisingly, financial aspects seem to play a large part in incentivizing or discouraging people to sign up to long-term agreements, but that administrative aspects and attitudinal factors, for example, how environmentally focused a person is, are also important. And among the literature on blended finance, we've found that this is currently kind of lacking in the context of agri-environment schemes, but taking learnings from other contexts like climate change and sustainability projects, we see that there's many forms of risk and uncertainty that currently deter investors from investing into blended finance projects. Not least, there's often an issue of how to produce evidence that the business model is worthy of investment, and the underlying institutional frameworks, such as the regulatory system in place, seem to fail to adequately instill confidence into potential investors. Next slide, please. We have here some findings from our initial scoping workshops. So we held 4 workshops, 1 with non-farming stakeholders and 3 with farmers and land managers across Hampshire and West Sussex. And during these, we discussed their current feelings towards long-term agreements and the key barriers and enablers that they saw to their own engagement in one. And as in the rapid evidence assessment, we heard a lot of views relating to matters of risk and uncertainty in many forms. Some of these concerns could be overcome by making agreements, for example, as flexible as possible to suit many different contexts, and also by engaging all parties from the outset so they have a greater sense of agency over the agreement that they're signing up to. But these workshops also emphasise the importance of robust yet transparent monitoring and evaluation procedures, not least because this will then feed into the adaptive land management that will likely be required to produce good environmental benefits over the long term. And crucially, it became clear even from the early stage that everyone, so farmers and non-farming stakeholders alike, need clearer guidance about a range of issues in order to make fully informed decisions as to whether a long-term agreement would be appropriate in their circumstances. Next slide, please. The next stage involved drafting a scenario around which our template long-term agreement would hinge, so that essentially we didn't have to discuss the agreement in an abstract sense. We could kind of frame it around a hypothetical project that both land managers and stakeholders could envisage themselves being involved in. So we developed 3 scenarios before these workshops, and then during them we fleshed these out with participants and sought the consensus on which they would like to take forward. So the scenario that was chosen was a natural flood management project, and this forms the basis for the agreement that was developed by Strutt and Parker. And during these workshops, again, risk and uncertainty were key topics, as were how an agreement might be structured and governed, and how a model of blended finance might work. Next slide, please. And then in our final workshops, we discussed initial drafts of the long-term agreement and focused on the key clauses within it. And we tested the suitability and attractiveness of these clauses for participants. And then from these, we further iterated that template agreement, as well as developing our key conclusions and policy recommendations to Defra. And then finally, we carried out some evaluation interviews with participants who'd attended at least 2 workshops during the test and trial to make sure they were happy with the final outputs. Next slide, please. And the next slide just gives our key findings from the discussions that we had on blended finance throughout. So we found that land managers feel quite selective about the potential sources of funding behind long-term agreements, with some companies like those seeking to offset, for example, being viewed far less favourably than others. In addition, land managers want to make sure that funders are trusted and stable over the long term in order to protect themselves and their own investments of time, energy and resources. But from a funding point of view, we found that many potential investors will be constrained by their own financial planning cycles, which might operate, for example, across a 5-year term only. So this curtails their ability to plan for the future, and therefore their ability to provide reassurances to land managers for the long term as well. And we found that among the possible approaches to implementing a financial arrangement involving both public and private funding, we found a stacked approach was the most popular. So we'll discuss this a bit more later, but it's essentially public money paying for one element of a scheme or one outcome and private money paying for another. So this is slightly different from a sort of true blended approach where public and private money would be pooled and used to pay for the same outcome. So that was a really quick overview of how we got to the template agreement. And in a second, I'm going to hand over to Hannah, who's going to talk us through the head of terms template agreement that she's drafted, and discuss those key parts of it in more detail with you. Okay. Hannah.
Hannah, you're on mute. There we go. Perfect.
It's a good start, always the way. I'm going to quickly run through the outline of my discussion today, which will be the crucial areas that were raised as part of the stakeholder engagement, the key concerns that were raised, and the what, how and who of the ongoing challenges to creating a long-term agreement and the heads of terms thereafter. Next slide, please. Lucy has already alluded to some of the issues surrounding the structure of responsible bodies and the use of cooperative law versus contractual law in very little detail. In this test and trial, we've steered closer to contractual law due to the various factors that we'll discuss in the following slides. But the cooperative model is also one that could be work dependent on the nature and requirements of the individual stakeholders involved in the landscape recovery scheme. While it's not part of the original remit, we spent some time in stakeholder workshops working through the implications of the different possibilities. And clearly this is dependent on what policy dictates as to whom can become a responsible body in respect of the environmental covenant law, but also who is going to govern, manage the finances and oversee the practical implementation of the scheme or schemes, dependent on your funding. It was generally concluded it would be dependent on a variety of factors, mainly determined by the management of profit and liabilities. It was clearly expressed to us about the requirement for individual entities to be able to maintain control of their land while accepting a number to be agreed management obligations. Where discussion was divided was in how to measure and prove honouring of these prescriptions and how to deal with matters when they all went wrong. It was proposed and accepted by most that there was a requirement for sort of 3 types of agreement tied together and running coterminous in a coterminous manner, along the same lines, same timescales, but individually identified for a specific task. agreement between the landholder and responsible body, the financial management, and the practical management, i.e. the sort of prescriptions and the actual delivery of the scheme. The agreement between a landholder and responsibility would set out the basis of the arrangement, the principles of the scheme, and the agreement between the parties and how they're going to collaborate. Areas included within these agreements included the parties' consents, term, the land parcels involved, the methods for dispute resolution, a breach of contract or terms, membership terms, change modification, including disposal and liabilities between parties. Financial management agreement would be the way that the finances are managed and how the individual
Oh, hang on. We seem to have lost Hannah briefly. Let's hope she's able to come back rapidly. I know they're at the Royal Agricultural University, which does have flaky internet sometimes. So fingers crossed she'll be back in a second. Here she is. Hannah, sorry, we lost you briefly. Are you back? Maybe if we stop your video and you just speak, let's see. Are you there, Hannah?
Am I back?
You're back, yeah. So we lost you when you started talking about the financial management side of things.
Perfect, thank you. So the financial management, this is the body will need to consider how it is managed and how the agreements are set up for the individual entities. Clearly, arrangements between landlord and tenant will need to be identified, including management prescriptions, but these will also feed into how the finances are dealt with to include the divisible asset, how the benefits of the scheme are apportioned between members of the scheme, how direct payments for works are carried out, the land area on specific land areas, and the profit income. And this is all dependent on the type of responsible body and whether it has charitable status. The final agreement would be the practical management prescriptions, which would, with options to modify and change with time and evidence for reasons that were for the change, and to really have that flexibility to allow the scheme to grow and change in terms of financing and involve other stacking of agreements. Although these agreements are running in line with each other, it was felt by having compartmentalized the areas that are likely to see most change, the principles of the scheme, the collaboration agreement could remain in place and not require additional costly alteration. We will address the change management as part of the key stakeholder areas of concern in the next slide, but it is important to note that by having mechanisms that are simple to monitor and change will assist in determining a successful outcome to the wider scheme. Next slide, please. Please note that I refer to landholders rather than owners throughout this discussion, as the holder can vary from a freehold landowner, the company, partnership, trust, long-term and short-term tenants, and a huge variety of other entities involved in the scheme. In this example, if you consider the scheme to be relevant to the lowland agricultural areas Charlotte spoke about in the introduction, but also having areas of water meadow and other beautiful wild features. So one of the key stakeholders and landholder concerns was the breach in the definition of agriculture. There is a clear definition of agriculture, and whilst this is altered and changed dependent on subsequent laws and policies, it determines the basis of most definitions under the 1947 Agricultural Act. For the purpose of the long-term agreements, taking land out for a permanent reason, saying changing its use from pasture land or arable to a permanent flood barrier, or putting in a woodland, could remove the productive nature, i.e. could be determined to no longer be agriculture within the definition. This may have implications in respect of potentially losing the right to claim agricultural property relief on death IHT, or indeed the nature of a tenancy could alter significantly. In our proposal, we discuss the requirement for management prescriptions to consider the nature of farming, consider methods of agroforestry or low grazing intensity as still held within the agricultural productivity and therefore within the agricultural definition. But also there is a government out consultation on the tax treatment of these schemes, as I'm sure you're aware. And I certainly recommend that we make sure our concerns and potential solutions are considered as part of this scheme. Secondly, the change or modification of occupation. It feels like the schemes are always dealing with landowners that have a static ownership or occupation, but as we all are aware, circumstances change fairly frequently: sale or disposal of land, new lettings, business strategies, or sadly death of occupants or owners. Our discussion with the farmer stakeholders in particular suggested there could be a tiered approach in understanding land parcels which were critical to the scheme, such as the ones with control structures or reservoir areas for flood storage, and areas that are transitional, such as rotational cropping management or lower input prescriptions. The penalties of the changes and the payments made for positive changes will need to be addressed and incorporated as part of the financial model. Thirdly, the success or failure of measurement. Much of the initial stakeholder sessions were spent on mechanisms on how to determine the success of a scheme and what the main indicators could be. Discussions on baseline monitoring and assessment, who is at best at doing that, how the measurements could be controlled, assessed in the future to create bona fide report of success or failures. Failure for certain key species not to return or enhance numbers, even if the landowner had carried out all of the management prescriptions, but no fault of their own. Should a penalty be paid? Would funders expect a rebate for this form of non-performance? The ability to add management prescriptions and financial incentives during the course of an agreement, and that was deemed necessary, and hence why we created the flexibility of having the two separate agreements that can run concurrently with each other. Next slide, please. I've already talked about funding and payments and split funding and payment from public sources and how to integrate were discussed in great detail. In these heads of terms, funding stakeholders had a variety of approaches in respect to the likely payment programme. Therefore, judicious management of these funds through the responsible body will be key. And would the landholder seek to obtain the full amount for the management, or the body seek a payment annually based on management prescriptions? Conversely, if an individual landholder was successful in obtaining, say, biodiversity net gain on their land, which forms part of the wider scheme, would this funding enter the bigger pool or paid directly to the landholder? This could be further complicated by tenancy and occupancy conditions. It is clear that within the heads of terms, these areas need to be assessed and talked about openly at the start of any negotiation and finalised within agreements. Divisible surplus and net gain. How the surplus is divided and managed will fall to the responsible body. A surplus could be generated where management and membership fees exceed the running costs for the organisation. Alternatively, how perceived benefits of the scheme could generate an income to the body. For example, if you have water meadows with a sort of glorious abundance of wildflowers and created over a formal redundant site of, let's say, negligible beauty, the owner of either the water meadow or indeed neighbours of the water meadow could install a high-end glamping site, benefiting from the views and the fully immersive experience of the water meadow generated by the scheme. This is a success partly as a result of the glamping site's owner's entrepreneurial spirit, but also because of the success of the overall scheme. There could be methods incorporated as part of a financial agreement to provide a proportion, say percentage of the profits, to the landscape body in the overarching scheme. Clearly, This proposal is fraught with benefits and opposed views on both sides. The owner could only create the site as a result of the scheme, but it would also have incurred costs and financial long-term management implications for the change of use of their land. Not everyone would want or need to go into hospitality or diversification, and therefore why should the wider scheme benefit? Careful consideration of the scheme setup could create options to allow for everyone to benefit from the success without imposing more obligations on those that wish to utilise opportunities as they present themselves. It is clear that communication, transparent and open, will be key to establishing precedents for future negotiations as part of the wider scheme to create the trust that will be key to success. Which neatly moves me on to the next and probably most contentious discussion point within the LTA stakeholders' discussions, joint and several liability. It is proposed that funders, particularly but not exclusively private, would expect the scheme to uphold all their obligations as a whole. So where they're paying a body rather than an individual entity, the body will have the responsibility to ensure compliance with prescriptions within the agreement. Again, to put this in more of a scenario context, a funder has paid a group of farmers to provide a reservoir facility, which in turn creates a wet bed for part of the year, enhancing wildlife and preventing flooding further downstream. This flood area covers a number of occupancies and ownerships. The funder would expect all parties to manage the land in accordance with prescriptions and to ensure the neighbours are joined with them. Non-compliance could result in either no payments or indeed penalties being paid by the landholders. Putting farmers to effectively be held to ransom by non-performance of a neighbour was felt to be very uncomfortable, and it would felt the significant blocker to progressing down a scheme similar to this if this was the case. It was recognised that there was a need to be areas identified where the impact of non-performance would be the greatest, perhaps the same areas alluded to in the previous slide, and these may have stronger performance liabilities than others. Resolutions and penalty measures will need to be in place so that all parties have the confidence in each other to perform. It must also be noted that whilst time has been spent dealing with what happens when it all goes wrong, there are numerous examples about the country where landholders work cohesively and productively together because there is the great respect and trust. Again, the mantra of change management was addressed, and the ability to have open conversation at the point of change is important. Finally, access to land was acknowledged to be a key part of public funding. There was discussion about the issue of control of individuals and larger parties in popular areas, combined with a requirement for public relations to set out clear reasons for preventing access. Understandably, there was a degree of scepticism whether this would work, but generally those that wish to be involved in schemes similar to this landscape recovery would wish to be able to inform and educate and explain why their work has been carried out and what is ongoing and why it is important. The liability of having public access was discussed, and whether it would form part of the overall administration of the scheme, combined perhaps with individual landholders' insurance. And I know that insurance came up as one of the questions which we'll address later on. Managed access will be necessary, and such as glamping sites referred to above, there'll be unique opportunities to expand access and essentially show off their work. Finally, next slide, please. Entitled What, How and Who, the ongoing concerns, perhaps the usual summary for a legal agreement, but the challenges to creating a long-term agreement for a similar scheme will be the same. Starting out with the premise that a long-term agreement is necessary, but is too difficult in the first place. Is that really the best way to go about things? Working with stakeholders involved in clusters, entities that are used to working alongside each other, but currently finding requirements particularly daunting. Large landowning entities such as the National Trust, for example, who already work alongside their occupiers, own large catchment areas and have a wider remit, will find it an easier process, I'm not saying that it won't be challenging, than perhaps a group of farmers with differing business structures and ownerships. The Land Chancery has put forward a terms of business for a collaboration agreement, which will allow entities to form a formal bond and work on the final body to oversee the final vision or scheme. Whether the parties agree to create a cooperative to manage the agreement, a limited company to gain from the profits or loss, or form a charitable in structure Each member will need to understand their responsibilities to the body group and their own liabilities in respect of adherence to the overall scheme. The how is the public-private funding going to sit alongside each other? Allowance for stacking is becoming clearer. Benefits and monitoring will be key. Funding bodies more often than not have indicated short-term funding arrangements. Tax, and particular inheritance tax, I've already addressed as part of my discussion, but this area and the ongoing change of use does need to be considered. The who. Perhaps the most controversial element of the stakeholder events is having the understandability of responsibilities for individuals and the group as a wider scheme. The flip side is the ability for the body to gain the benefits of the scheme for the greater good and be able to recirculate the money and have a return on the investment that individuals and public bodies and private bodies have made. Communication. The benefit of rewards versus the perceived hassle and responsibilities within the types of schemes will rely on clear communication of facilitators to drive results. Where trust is broken, it's always there's a perception of hidden items or agendas. Already discussed, but the funding mechanisms and the accountability of managers of the scheme, the body, the landowner, the occupier, will result in a success or not. I'm going to hand over to Lucy to discuss the next steps and the future requirements as a result of our exploration into determining the heads of terms for long-term agreements. It has been a challenge and a pleasure to work with all the participants, and thank you all for your contributions.
Thanks so much, Hannah. So there was an awful lot of information there, and we've got quite a lot more to come as well. We're going to take a 5-minute break, so please do grab a cup of coffee. And when we come back, I'll talk through our key conclusions and the policy recommendations that we've put forward to Defra, particularly focusing on how to make long-term agreements more attractive in lowland agriculturally productive multi-ownership contexts. But 5 minutes, that makes it 1:18 by my time, and we'll be back with you then. Okay, thanks. 1:18 by my clock, so I'm going to carry on because we are possibly a bit pressed for time. So on our next slide, you will be able to see a graphic with our key conclusions that we've drawn from the test and trial. And I'm going to talk through these and then our main policy recommendations. I'm going to try and do this quickly so that we leave plenty of time for question and answer and discussion at the end. But as I mentioned earlier, our final reports and the head of terms agreement are publicly available now, and we will provide you with the link to download those and read at your pleasure if you would want to. So you can see all of these in far more depth there. So I apologise in advance if it's going to be a bit of a kind of information overload in the next 10 minutes or so. But looking at our key conclusions, firstly at the top left, you can see that we've pointed out some of the main barriers that we think still exist when trying to coordinate environmental actions at a landscape scale, and that these include mismatches between the scale of agricultural management, for example, farm boundaries, and the scale of ecological processes. And we've also identified mismatches between land ownership, tenure, and the term of, for example, a 30-year agreement, if that's what we're saying a long-term agreement is 30 years plus. And we've also found mismatches between that potential 30-year agreement and the timeframes of business planning that both farmers and potential funders operate within. And then the top and bottom right of your screen, although long-term agreements clearly need to be bespoke to account for many different circumstances, they need clear documentation to cover financial governance and land management aspects, and this necessarily makes them complex documents. And we found in particular that the bureaucratic and administrative aspects of setting up, especially a multi-party agreement, which is what we've aimed at doing in this test and trial, and also its ongoing management across the term, are really overwhelming for many land managers. And then in the centre, you can see the main areas in which we feel that more guidance from Defra and from government in general is needed. We'd really like to emphasise the taxation issue here. So as Hannah mentioned, there's real concerns about the definition of agriculture and how that might be impacted by participation in landscape recovery. But we also had one stakeholder who expressed real concerns that actually individual landowners might be crowded out of long-term agreements for landscape recovery because organisations like wildlife trusts, for example, they simply don't have to worry about matters like inheritance tax and capital gains. So it removes a significant area of concern for these organisations compared to the individual land manager. So that definition of agriculture is definitely more information is definitely needed on how that is going to alter, if it's going to alter in the future. And next slide, please. So overall, we found, we said that our findings, and I would re-emphasize that specific context of being a multi-party agreement across agriculturally productive land, we've said that we feel that uptake of such an agreement for landscape recovery under ELMS is likely to remain limited, particularly among smaller to medium agriculturally productive landowners. Is likely to remain limited until some of the major concerns can be mitigated. And we feel that this could have clear implications and clear kind of negative consequences for what Defra have termed a just transition to the ELMS schemes. Next slide, please. So with all that in mind, our policy recommendations to Defra. So at the top of each slide, you can see the main policy questions that we're responding to. So these are the ones that Charlotte mentioned right at the beginning of the webinar. So on this slide, we are talking about how to safeguard investments in land use change and environmental outcomes. So as I've said, the context is really important. So the type of agreement used will necessarily differ according to landscape recovery projects and to the composition of land managers, stakeholders and funders involved in it. And while it would be good to keep agreements as simple as possible to really broaden their appeal, we feel that a facilitator may well be required where multiple parties are involved, and that the costs of this will need to be factored into the planning of agreements. Some form of land designation, possibly a conservation covenant, could be used to safeguard changes in land use. But some stakeholders have indicated that these may not be a necessity for them to consider funding a long-term agreement. And farmers have also pointed to things like environmental impact assessments as being perhaps one way in which the need for putting in place a statutory designation from the outset can be avoided. And actually, if you can avoid such a designation, you may remove one element of cost and also one element of concern from an agreement. So keeping agreements as flexible as possible whilst ensuring that they are robust to change would also likely increase uptake. We've said that provisions for modifications and discharges must be put in place, and agreements need to be able to respond to the results of a programme of regular monitoring and evaluation. But it's vital that this is carried out in a robust and transparent way, so its results are deemed to be fair and trusted by all parties concerned. And as Hannah sort of alluded to in her presentation, land managers in particular want to see public engagement and education built into the landscape recovery scheme, and possibly even into individual agreements, because changes in land use are so that changes in land use are understood by the wider public, and so that projects are not, for example, endangered by inappropriate public access. But as the quote from one farmer participant on the right-hand side of the screen shows, sustained engagement among agreement holders is going to be crucial for the ongoing success of any long-term agreement. Next slide, please. So when we thought about how to incentivise land manager participation, lots of the previous points also apply here, particularly keeping things as simple and flexible as possible, but also making sure that there are periodic review points. So our template agreement has provisions for 5 yearly reviews, but it may even be that 3 years is more appropriate in some circumstances. But crucially, it needs to be emphasised that anyone considering a long-term agreement, that these are not like previous agri-environment schemes where you're signing up for 5 years with the option to renew for another 5 at that review point. It needs to be made clear to anybody that they are 30-year agreements, and that the 5-year point is simply the moment at which you might adjust your agreement to better achieve its aims. It's not simply a point at which you can walk away without very good reason, and likely without incurring quite harsh penalties as well. And we've identified here some key areas in which land manager confidence, both in landscape recovery and in long-term agreements, might be increased. So again, addressing these could result in an LTA and in landscape recovery appearing more attractive prospect for the future. And next slide, please. And when we considered payments to land managers, achieving security of financing beyond the initial period is a real concern for farmers, although some do see real opportunities to attract a wider range of funders once they have a kind of proof of concept for their landscape recovery project, and therefore are able to demonstrate its potential to investors. But given the current rates of inflation and the political and financial instabilities that have occurred in recent years, having regular reviews of payment rates is absolutely crucial to make long-term agreements attractive. And while upfront capital payments are relatively easy for some organisations to make in terms of their financial planning, farmers generally aren't too keen on this, as they see its value being gradually depreciated over time with inflation. So what might have seemed a good deal now in 30 years might seem actually to be a very small amount of money. So what appears to be most attractive to farmers is a mix of guaranteed and bonus payments. So giving farmers a guaranteed minimum income for their participation, but then the opportunity to earn more if they achieve, for example, a higher amount of environmental outcomes. And one way of achieving such a model might be if we use a stacked rather than blended finance model. So rather than the public and private money being blended and put towards the achievement of the same environmental outcomes, you might have public money paying for one particular outcome and private money paying for another. And farmers in the test and trial have been particularly keen to stress that actually if the stacking of various long-term agreements on their land isn't possible under landscape recovery, then they would be very reluctant to enter the landscape recovery scheme, because they see the potential opportunities from the emerging natural capital markets and they don't want to shut themselves off from those. And that's especially true of the farmers that participated in this test and trial. So if we bring it back to the geographical context again, that being in the southeast, being in an area of high development, some of them have already been approached by various organisations looking to secure, for example, sites for offset or biodiversity net gain. And we actually had one farmer who described himself as very ecologically minded, yet said that if the stacking of agreements wasn't allowed under landscape recovery, then he simply wouldn't enter the scheme because it would jeopardise the future of his farm business and its viability. So if we consider other ways of achieving high quality and quantities of environmental outcomes, we think there's a real opportunity for Defra to facilitate connections between ELMS agreement holders to create a much more joined approach across the landscape. And that applies no matter which tier of ELMS those agreements might be under. Next slide, please. And lastly, if we just consider the blended finance aspects, as I just mentioned, a stacked rather than blended approach might work best for farmers, but we also were hearing that it might work best for potential investors as well, as it would enable them to claim ownership over associated outcomes. This might better suit their business model, particularly if they have customer facing or ESG elements to that. And thinking about as one stakeholder put it, the multiple functions across a landscape enables us to see more clearly the different opportunities that there might be to stack environmental outcomes on the same piece of land. And it may therefore be the case that we see public money, Defra money, supporting the delivery of public goods, while other things might be more natural areas of investment for private companies. And whatever form of funding model is used, we think it will depend in a large part on the limitations of potential funders' financial cycles. And crucially, that the regulatory frameworks behind such investments need to be clear and robust. And again, we think that government has a clear role to play here in establishing those regulatory environments. So far, we've given you a really kind of whistle-stop overview of the test and trial as a whole and its key outputs. So, as I said, full details of all of these are available in our report to Defra and in the finalised head of terms template agreement that's been produced by Hannah. So do please look those up if you can. But we've now got almost half an hour left, so we can take your questions and answers, and I will hand back to Charlotte, I think, at this point.
Yeah, brilliant. Thank you, Lucy, and thank you so much for talking through all of the findings. Yeah, I do appreciate that it's been a lot. As you can understand, long-term agreements do include a lot of legalities, a lot of clauses, and an awful lot of different potential barriers and opportunities. So hopefully you're not all exhausted after that. But we have got some questions in the chat, and it would be great to start answering those between us. Some of them have been answered in the chat, but we might expand a little bit more verbally. Feel free to keep posing further questions as well, and drop a message in the chat as well if you'd like to actually come on camera or off mute to sort of share any thoughts. We'd be really, really happy to hear from you. So first of all, I'm going to sort of start off with a question that we've had from David Baxter, who works at Baxter Environmental. So he's asked, so where private investment occurs, I presume there are outcomes that the investor requires. Have you looked at what, if any, insurance should be used by the landowner to cover the prospect of these outcomes not being delivered? So I can answer the first part. Yes, it's very, very likely that investors would have outcomes and expectations that they would have from a long-term agreement. You know, they want to know what they're going to get out of paying towards these long-term agreements. The nature of these may really vary, though. It depends on the organisation and how rigid they feel they need to be. And clearly, you know, having outcomes based sort of metric, it's very difficult, because in some cases you may have something like extreme weather or some other situation, which means that actually the outcome that the investor thought they'd have may not come to fruition. And that's something else we've had to really think about when developing the head of terms. So I'll hand over to Hannah in terms of the sort of insurance side of things, and what happens, as David says, where these outcomes are not delivered.
I mean, have we looked at insurance in a wider scale? And in short, the answer is no. I think, you know, with this scheme, there's going to be a variety of insurance areas that we need to consider. When we were working with stakeholders, there was various discussions of holding money in bonds of sort, partly to pay out the annual payment for management prescriptions, but also for the non-performance element. You know, the wider insurance implications are huge, particularly as you'll all be familiar with public access and the requirement for and the liabilities that cover that. But it's certainly in an area that we'll need to explore and expand upon when studying the landscape of responsible bodies as a wider study area.
Can I just follow up a little bit? Thanks for that. I mean, this is all about how you apportion liability, isn't it, really? And is it, because if you're a landowner and you go into a contract and you've delivered all your management prescriptions, but the project just hasn't delivered. So if you said, and I'm thinking perhaps here in the context of biodiversity net gain, where the habitat just has not responded. You've done everything in the plan. You've done what you've been paid for, but the habitat hasn't responded. Is that that's one scenario? Is the landowner liable? Question mark. Because I don't think you can insure for that, because there's no way that an insurer could understand the risks around that, I don't think. Okay. But then, as you say, there's a force majeure risk, which might be, you know, what are the consequences of a bigger storm event on this habitat? Would it fall over and just fail? And I guess in those scenarios, you've got to say in carbon, in woodland or in peatland, you've got the whole concept of a buffer. So maybe at a landscape level, you've got to think about how you self-insure almost, and just say that everybody who takes part in the landscape scheme has a contribution to a buffer, and that is held as a, so perhaps as just, it is going back to that need for a kind of overseeing body that can govern the risk, perhaps. I don't know if any of those things came up in your discussions.
Yeah, I think that's absolutely right in terms of the responsible body being able to buffer the storms effectively, but also control the benefits. And having that open discussion from the start is, I think, going to be quite key.
Yeah.
Brilliant. Okay, so I think we'll move on. And again, there is still lots more research that we'd probably like to do on these topics going forward, because there's a lot here. But so another question is from Lisa Lobry-Debrien, who I know is in Australia. So thank you so much for sort of staying awake so late. So I understand it's quite late in the evening there. So thanks for joining us, Lisa. But Lisa has asked, do the landholders have to secure financing for the recovery? So she's just not sure exactly who secures the financing for the recovery of the landscape. So as far as I understand it, it might be landholders, but it also could be a facilitator. So under our head of terms and also our sort of final recommendations, we found that you would need to have hopefully a really strong facilitator who could, with a collaborative approach especially, you'd have to bring them all together, and then you'd have a facilitator who might help with liaising, you know, almost acting as a sort of middle person to liaise with potential private funders and also with Defra, and also, you know, and this could become quite costly, as you can imagine. So setting up the landscape recovery long-term agreement could involve quite a bit of cost, just in terms of getting agreements set up and securing the financing in the first place. I don't know if anyone else in the team has anything further to add to that. No?
Yeah, I can jump in. Sorry, just to make 100% clear that yeah, Defra kind of provide, I don't know that seed funding is the right word, but for the projects that are currently it is a pilot. So Defra provide public money for that, but the expectation is that going forward, so once those projects are actually in what they call their implementation phase, that they will have secured for themselves sources of private financing as well. So it is very much up to each individual project and the agreement holders within that to go out and seek sources of private finance. Yeah, just to 100% clarify, I hope.
That's perfect. Thanks so much, Lucy. Yeah, absolutely. That's a really important point. So Henry Levson-Gower has just asked, why did we separate farmers and other stakeholders in your process? So the reason for this is because it's such a complex topic, and we also wanted to make sure that because we worked with a specific farmer cluster who already know each other and trust each other, it meant that we had a really safe space for them to give their really honest opinions and share what they genuinely thought. Whereas the concern would be that if we had stakeholders, which could include the private funders in the room, in the same space, it might have really caused some tension. It could have really shaped the discussion. Equally, if you have farmers and influential stakeholders, so for example, their own extensionists or advisors in the same room, that can lead to them sort of just deferring to whatever the stakeholders' opinion is. So you need to be, we just want to be careful to make sure that the landholders had their own space to share what they thought, and then that the stakeholders also had that space. And then we brought them together. And the fantastic thing is that even though we went into it thinking that the private funders especially would have quite a different approach and quite different views to the farmers, they actually didn't in a lot of cases, and there are lots of synergies. So we've managed to put it together into a set of policy recommendations that both our farmers and stakeholders agree with. And we've sort of, we've actually evaluated that through our evaluation interviews. So we have double checked that everyone involved in the test and trial has been happy with how we've interpreted their findings. So yeah, so we think it works quite well doing it that way. So does anyone else from the team have anything to add to that?
I think I would just add that we felt it was really important to talk to farmers in person and actually sit in a room with them. And just given the kind of broad range of stakeholders that were involved, you know, it was not going to be possible for us to do those non-farming workshops in person. We simply had to do them online. And we didn't want to do that in the case of farmers. And we think they've probably had enough of Zoom meetings during the pandemic.
Yeah, absolutely. Having the farmers in person was brilliant, because it also meant we could, you know, give them a bacon butty and you know, thank them for their time through vouchers and things. So I think it just really helped to keep them engaged. And they were absolutely fantastic. You know, we've had some really engaged participants, which has been lovely. So I'm just going to go over a question that actually Hannah has answered briefly in a chat already, but I thought it might be good for Hannah to just sort of verbally expand on it, just because I think it's a really key question. So this is from Julie Robinson at the National Trust. So this is on the structure of the Landscape Recovery Scheme delivery bodies, and she's asked if we could just expand on the difference between cooperative law and contractual law.
I think, you know, putting that really in a really simple context is answered within the chat, as you've said, Charlotte. I think, you know, the cooperative law relies on working together in the form of membership with mutual agreements and expanding thereof. We have an expert who has offered his services in terms of the River Ribble on the chat at the moment. It we believe that it will be a form of a spectrum that's going to be able to make the landscape recovery schemes actually work. There is going to be a requirement for collaboration agreement across the board, whether it's a form of cooperative law or whether it's contractual, which is slightly more prescriptive. There are a lot more terms, and it's, dare I say, more nitty-gritty. The contractual law has its benefits in that the areas for contention have been addressed and thought of, and perhaps it's the ones that aren't in print, in more so in cooperative law, that can cause the problems. The difficulty is it can build that when you're working on a contractual arrangement from the start, it can cause mistrust and misunderstanding, because there's a kind of accusatory nature in the form of heading down that route. I suspect, dependent on the setup of the responsible body or the governing body that's overseeing the scheme, and the landholders that are involved within the scheme, there'll be an area where they'll be collaborating, and there'll be an area where they feel they need contractual agreement, and more so where the financial arrangements come into place. It is more likely that you will see more contractual arrangements. I kind of talked around that area, but I can see Henry Leveson-Gower's got his hand up, Charlotte, and it'd be really great to bring him in if we can.
Absolutely. Yeah.
Thanks very much for letting me on. I just thought, I'm not sure if it's quite a spectrum as such, because in a co-op, there's nothing to stop you having a very prescriptive, precise agreement between members. So, you know, you could have something between members that looks very like a contract. There's nothing against doing that. But what you can do as well is have lots of rules of how, if a problem arises, members get together and we work out what to do. So it'll say who's party to that agreement, or who has to be part of decision making and things like that. So its focus is on process, and contracts aren't very good, as far as I'm not a lawyer to say this is what I've learned from people, is that the one thing in a contract you can't have is an agreement to agree at some point. That's what I'm told, because that sort of falls down because it's totally unspecific. And the contract law requires you to be very specific. Whereas in cooperative law, you can have both the specific if you want to, but also the vague. And all the rules about exits and entries, and and what. So, and you can adapt and change it.
Yeah, I do. Are you coming in? Oh, sorry. Apologies for that. I can see that Julie Robinson has her hand up. Julie, do you have something further to follow up on that, or I can respond?
Yeah, hi, everybody, and Hannah. I think my query was because co-op law is just contractual law. It's just a contract between the members, in the same way as if you set up a private limited company, you have a contract. It's just really whether you really meant co-ops, as in cooperatives and community benefit societies are not the way forward for this, or whether you meant that the cooperative model itself wasn't going to be suitable because there'd be ancillary more commercial agreements. But that's what in the co-ops that I've set up for delivery of environmental agreements, we have quite a complex membership agreement which sets out payments, force majeure, non-delivery, penalties, etc., etc. It was just that query really as to what you meant by cooperative law, and whether you meant the formal co-op structure that exists.
Right. It's more in the formal cooperative structure. And I think it's not a negative, as you correctly say. You can use it. And I think it really will fall down on the nature of how the bodies are set up to govern and how individuals want to collaborate and work together.
Because that's basically, it's the relationships that the co-op sets out, which then has some specifics as they turn up and things evolve. But it sets out how it sets out an ongoing relationship. That's the key thing.
Yeah, and I'm not
a shared.
And to be clear, one is it's still the sort of very much a working body, and it wasn't meant to form part of the wider remit in terms of the project that we're working on today. But I think it was an acknowledgement that there are different forms and different structures for which these terms can be used either as whichever way down you choose to head. Does that make sense?
Yeah, I think that's great. I think it's really good that we've had this discussion, and I think there's a lot more discussion that could be had actually. And I'm hoping that with the next steps after this project, it might be that we get the opportunity to delve deeper into these things. And also it'd be lovely to learn from others who are doing similar research into long-term agreements. So it'd be great to touch base with you both, Henry and Julie, after this. But we've got a few more questions that it'd be great to sort of get answered. So we've got one here from Henry Vane. So Henry has asked, in your view, should responsible bodies be charities and non-profit making, or could they be profit-making businesses? Well, this is something we deliberated over for quite a long time, so you can see Hannah laughing. But I don't know if Lucy or Hannah, would you like to take this one?
Okay, I'll start and Lucy can follow up. I mean, I think we've just pretty much alluded to that. In my opinion, do I think it should be a charity or profit making? Both have benefits and both have negative issues. I think ultimately, from my perspective as a land manager and working with a variety of private investors and institutions, I think the ability to see a return on investment for the individuals that's expending energy in a purely monetary way would be extremely beneficial. However, the hang-ups that entails in terms of the collaboration agreements will involve significant discussion. But it goes back to the open communication, and it goes back to the trust and the development of whatever membership you prefer. I'm also working with charity institutes, and they have excellent structures, and you have an excellent way of working with them. But the financial agreements, again, will have to be very strong, and it will be down to the facilitator and the administration of whichever body will determine the scheme irrelevant if it's private or set up as a SIC or a CIO. Lucy, do you want to pick up?
I was just going to say, all I can remember from the workshops was it was very clear that the land managers may have a view, but they need to take into consideration what the buyers, if you like, the other stakeholders, what they're. So if you choose one option, it could potentially exclude you from certain types of funding, which may or may not suit your some of the other stakeholders. So it is something that all parties need to consider carefully at the beginning. Henry, you have your hand up.
I think there is a spectrum here between a charity and a private company, because actually co-ops interestingly sit in between, and they're not generally not technically co-ops, not charities, but they can have objectives for the common good of the members, and members can be quite wide. So they're actually acting in the wider interest without being a charity as such.
Thanks, Henry. Yeah, I would just add that I think it has to be context dependent. So again, I would go back to emphasising that we were working with agriculturally productive land managers. You know, they relied on their land and their agricultural income for their businesses. So the ability to actually make a return and actually to withdraw that to invest back into their businesses was crucial in that context. So that's why we didn't go down the more charitable route when we were thinking about the particular vehicle that they would have set up.
Brilliant, thanks everyone. So yeah, absolutely, and you know, we did find that long-term agreements would likely need to be really quite bespoke, because as we keep driving the point that, you know, context is everything here, especially when you've got people collaborating, you need to really think about the context. So we've got time for probably one more question before we move into closing remarks and a final poll. So this is a quick question from Lisa Lobry de Bruyne. So she's interested to know how less business-minded landholders might navigate such a scheme. Would they have the fluency to deal with such a complex agreement? So I think that our sort of finding that actually you would need a facilitator or someone who is really involved in helping those collaborations to form and helping to encourage these landholders in would be absolutely critical for this. You know, you cannot expect, I think even business-minded landholders might struggle, you know, in a lot of cases with this. So I think it is really important that you have sort of highly skilled facilitators. You know, Defra and any other stakeholders would also need to be fully on board to help. And, you know, paperwork and things again would have to be, there'd need to be a lot of support there. And, you know, yeah, I think that is absolutely key. Lucy, Hannah, do you have any other comments on that? Right. But yeah, I think the risk is that, you know, I think when we went into this, we were sort of concerned that we wanted to make sure it wasn't that landscape recovery and these types of agreements don't only become attractive to sort of really large estates who already have that ability in-house to deal with these things. You know, we're really aware of that, and we're trying our best to find ways of making sure these things can be more collaborative. So I think unless anyone else in the team has anything else to say, I think it'd be good to, no, we're good. Yeah, okay, cool. So it'd be good to we'll briefly talk about what we're hoping to do next. So in terms of this test and trial, it is very nearly over. We've got another couple of weeks. So based on today, we might make a few very final tweaks to our policy recommendations, because as I said at the start, we wanted to make sure this is completely co-designed right until the end. So even now, when we've produced our final report, we are still making tweaks based on what you know people are saying to us and approaching us with. We are then sort of looking into the idea of potentially trying to see if we can get another test and trial running. That's very, very early days. We don't know whether we will, but it would be really interesting to sort of go deeper into some of these sort of nitty-gritty bits of long-term agreements, and to continue working with our farmers and stakeholders who've been absolutely brilliant. So yeah, so what I'm going to do now is I'm going to sort of put a final poll live. So this is just so that we can see whether you found today useful or not, and whether you feel that your knowledge has now improved surrounding long-term agreements. So please do take part. It just helps us to see whether today was successful or not and useful to you all. But yeah, in the meantime, please do feel free to get in touch with us if you have any comments on the final report or recommendations. I believe the test and trial ends at the beginning of May, so any feedback would be great before then, if at all possible. Today has been recorded as well, so we will circulate a recording. So yeah, brilliant. Okay, so yeah, looks like it's been quite interesting, broadly speaking. And yeah, a bit more understanding of around long-term agreements. That's really positive. Fantastic. But yeah, and yeah, it's really interesting to see that actually quite a few of you are saying that it has either somewhat or definitely sort of changed how you think about long-term agreements. You know, we haven't got any, we've not put our own personal views into this at all. This is very much what our farmer, landholder and stakeholder participants have found, and also based around literature. So yeah, that's brilliant to see that we've hopefully helped a bit. Okay, so I'll end the poll. Thank you so much for taking part in that. And yeah, do feel free to stay in touch in the future. It'd be brilliant to continue these conversations. And again, thank you so much for the rest of the research team, particularly Lucy, Hannah and Chris. It's been brilliant. Thank you to Jane, who's been in the background today, sort of copying questions across into a separate document so that we don't miss any questions. So yeah, thank you to everyone. And yeah, I think that's it. I think we're good to go. And anyone who hasn't had lunch yet, I imagine you'll be running off for lunch now, so enjoy. And yeah, see you all soon. Thank you so much. Bye.